Sir, once again, you interrupt me one more time, I will hold you in contempt of court. The first time, it's 1 day in jail. Are you clear about that? Listen. Van Buren doesn't work for me.
That's not the problem.
This is a court case.
I understand.
What do you have a question for me about the court case proceeding?
Who would I talk to that doesn't cut me off so that I can get the story out?
What story? That's got nothing to do with what's going on here. You're charged with domestic violence. What's in front of me, so the only thing that I've got to determine or make sure gets determined is whether or not on March 1, 24 in Van Buren Township, you committed domestic violence. So if there's a jury trial, I'm going to oversee the jury trial and let the jury decide whether or not if that crime was committed on that date. Jason Shepard.
Yes, Your Honor.
Fellas, your appearances.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Thank you.
Good morning, Your Honor. Daniel Bater on behalf of Mr. Shepard.
All right, and we're going to adjourn for a final with the complainant to be present.
That's correct, Judge. April 3rd at 9:30 if possible.
Unless Heather tells me no real quick. 9:30 will work.
And we need to address a bond issue if possible, Judge.
All right, let's see what we got for bond now. Make sure we're on the same page. I've got a $10,000 personal bond.
Correct.
Standard conditions and not to harass, intimidate, molest, etc. Rosemary Appleyard.
Okay, so there is no issue with him having contact, Judge.
I don't
correct?
see a no contact.
That's what he thought. When he was arraigned in front of you, he explained to you that he's her caregiver. I looked it up online and I saw no contact with victim. Maybe I saw something I shouldn't.
I didn't do the arraignment just for so records clear. It was an out-county arraignment, but it looks like it's a not to harm, harass, or confront.
Okay, then we're set, Judge. Not an issue.
Okay, so bond will continue.
All right. Thank you, Judge. All right, you're all set.
Have a good one, fellas.
Let me give you a note.
Oh, we're gonna get the notice. Have a seat, Mr. Shepard.
What else is right?
I think that's it.
Oh, I thought you said you had two, Freddie.
The other one was adjourned.
It's a shocker.
I'll have another one for you shortly, which is another bond issue.
Thank you.
Just so that you're aware of
What file is that?
Christopher Stewart.
Stewart?
Yeah.
Thank you.
What in the world's going on? We can't get some flow going.
No, I don't know.
I mean, it's 9:30. This was a good sized document.
Can you ask Mr. Washington, he's on Zoom, if he's ready on read?
Read. Mr. Washington, are you ready on read?
Yes, Your Honor.
Awesome. Your appearance, please.
Yes, good morning, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Billy Ray Reed. Mr. Reed, if you can state.
Mr. Reed, activate your camera if you've got one, please. There you go. Thank you. Mr. Reed, can you hear us okay? Thank you. Go ahead, Mr. Washington.
Judge, I just received a discovery on this, so I'm requesting a preliminary examination date.
April 17th available for you?
You only have 2 o'clock left. I'm not sure if you have to look at tomorrow.
Yeah, that looks like a good date.
That is a good day?
Yes.
All right, let's do 1 o'clock.
Okay.
Mr. Reed, that works?
Yes, Your Honor.
I will continue your bond.
Thank you very much, Your Honor.
Thank you.
Yeah, have a good day.
You ready on Stewart?
Yes, sir.
Yes, Judge.
Appearances.
Good morning, Your Honor. Patricia International for the People, P840.
Daniel Bater on behalf of Mr. Stewart. Your Honor, Mr. Stewart, come on up. Judge,
And
we're
what are we doing?
final pre-trial on April 3rd. Complainant must appear. And then we would like to address a bond issue.
I don't think he's got a bond.
If he hasn't, Judge, it might have been an out of custody arraignment,
We'll do
so
that 9:32.
Yep, same time.
Yeah, I don't see where there's ever been an arraignment.
No, today's first hearing.
Yeah, so we can do an arraignment. Would you waive formal reading?
We will, Your Honor.
I'll enter a not guilty plea.
Thank you, Judge.
Let me see if there's a bond rec in the file, gentlemen.
Let me call you right back.
Doesn't appear that there is. Do the people have any bond? Oh, here we go. Police Department requests a cash bond.
Here we're watching a completely different stage of the process. A defendant considering a plea agreement instead of taking the case to trial. The proposed deal includes probation and possible classes, but notice the judge's explanation. The recommendations are not automatically guaranteed. The court still has to review the circumstances and ultimately decide what sentence is appropriate. And before accepting a guilty plea, the judge has to make sure the defendant understands his rights, understands the consequences, and is entering that plea voluntarily. That's a crucial safeguard in the criminal justice process.
Prior police runs, prior incidents with same complainant, requesting 5,000, 10%. And that's all they're requesting. Ms. Mandernack, anything to add?
Your Honor, I have no objection to the 5,000, 10%.
Your turn, counsel.
Judge will ask for a personal bond. There was a divorce that was going on. That divorce has now been settled. They're no longer living together. He's living in Monroe. There is a custody order in place, Judge. He came here to court voluntarily today. Not voluntarily. He was ordered to come to court, but he showed up here today, Judge. So I don't believe he's any type of flight risk. We're asking you to give him a personal bond.
All right. Did you say divorce is final?
Yes, divorce is
All
final.
right. So I'm just going to order, and
And there's already a PPO in effect too, Judge, so he can't have any contact. This incident was back in April of last year.
I'm just going to make a note not to harm, harass, or confront.
Well, one other thing we are requesting, Judge, again, there is that custody order in place. The only thing he would like permission to do is to discuss the care of their children, and they actually have an app that they use.
Not to harm, harass, or
Okay.
confront. So that doesn't say no contact. That just means no threats, no harassment, et cetera, et cetera.
There you go. Yes, sir.
I'm sorry, Mr. Bahar, could you please put the case number for the custody, for the divorce on the record if you have it?
I don't have.
Okay, never mind.
All right, so I'm going to put you on a personal bond, sir. First condition is the obvious one, stay out of trouble. Second condition is almost as obvious, be here in court for April 3rd. Third condition, not to harass, harm, or confront the complainant. Understood?
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess that up?
Yeah, yes.
You just give me an IOU. All right, anything else, gentlemen?
No, Your Honor, thank you.
Yeah, have a good day.
Thank you, sir.
You're
All right,
welcome,
see if
sir.
they're gonna give you a notice, okay?
Are we ready on Evans?
Yes, Your Honor.
Appearances, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Hey, good morning, Your Honor. Attorney Michael Kelly, P77187. On behalf of Ms. Evans, who's present, approaching to my left.
Good morning. What are we doing today, counsel?
Your Honor, today's date and time set for pre-trial in this matter. I did just receive the completed digital discovery this morning at 9:12 a.m. Obviously, I need a little bit extra time to review this with my client. So I'd just be asking for an adjournment, Your Honor.
Pick a Wednesday, any Wednesday.
Any Wednesday, second week of April, we're maybe looking at. Wednesday, April 10th.
Fine. And that's going to be with Judge Martin, so that'll be on Zoom. How about 9:15?
That works.
All right, bond is continued.
Are you the only one doing in-persons?
I think so.
If we want to do it in person, would it be with you then on another date?
Yeah, I'm back on April 17th and April 24th.
We do the 17th.
No, I'll take when I can get it. Let's stick with the same time then, just a week later.
9:30.
17th and 9:15.
All right, thank you, Judge.
And then we'll get you a paper notice.
I'm sorry, Your Honor, I do have one bond issue to address.
Go ahead.
We would be asking for a civil standby for my client and her son, who both lived at the residence, to be able to regain some property and personal effects.
Yeah, you don't need to change the bond. Just set that up with Van Buren Township.
Okay, understood. Thank you, Your Honor.
Thank you, sir.
You're welcome, man. Mr. Coleman, are you ready on anything?
I am, Judge. We have one matter before the court. It's an arraignment pretrial. Dietrich,
And what's the name?
Brandon Dietrich.
All right, appearances.
I think it's our DV prosecutor.
Diedrich, is that yours?
I'm sorry, which case?
Diedrich, Brandon, first name.
It's a DV case, Your Honor.
I am not seeing that on my list today. Yes, that's not my case, so
Okay.
probably not.
Well,
Partner Violence TV.
For the record, Your Honor, I acknowledge receipt of the complaint and warrant, waive reading of same, and stand mute.
Thank you. Honor not guilty plea for your client. Are you ready for another pretrial date, or you want to talk to the prosecutor and see what you can figure out?
Well, I think we do need to set another pretrial. I'd ask for an in-person pretrial. I noticed that
April 17th.
The 17th?
Correct. My courtroom.
And that's
9:15.
at what time?
9:15.
Thank you, Judge. And that will be both us and the complainant.
I'll make a note of that. We can have the complainant here.
I would ask that the complainant be here so we can
That's
settle some
plenty of time. The
matters.
prosecutor can get that notice out. Let's talk about bond, counsel. Client has not yet been arraigned, so we get to set a bond. The police department's asking for a cash bond with no contact with the victim and no mood altering substances. That's the request from the PD.
He has no drug history, and this is a matter that was alleged to have happened in.
Hold on, counsel. Joe, I can't hear him when you're out there talking. Counsel, start over. I had people talking in the courtroom.
So my client has no history of substance, alcohol abuse. This is a matter that was alleged to have happened in November of 22, and the complaint, the person comes to the court in January. He moved out of the marital home in December of 22 and served her with a notice of divorce. So there's some issues. He's reported he got notice. Once he got notice, he contacted counsel, and we're before the court today. So I'd ask for a personal bond. He has no other history.
Mr. Coleman? If I order no contact, is that going to cause any issues?
Oh, no, none at all.
All right. And there's no reason for Mr. Diedrich to go back to the address on Pine Drive?
No, he's moved out. He stayed out. In fact, I think, so again, I'd ask that they both appear before the court on our next court date, that's April the 17th at 10 o'clock.
9:15.
I'm sorry, Judge, 9:15.
That's all right. All right. Mr. Diedrich, I'm going to put you on a personal bond. The first condition is the obvious one, stay out of trouble. Second condition is obvious as well, be in court on April 17th. Thirdly, have no contact with the complainant, no social media contacts, no phone calls, no letters, don't have your friends talk to her. You run into her at Burger King, you eat at Taco Bell, no contact at all. And do not go back to the Pine Drive address. You understand all those terms, sir?
Yes, Your Honor.
Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on the bond conditions?
I do, yes, Your Honor.
All right. Anything else, Mr. Cole, for the adjournment, sir? Are we ready on Willingham?
Yes, sir.
Appearances, please.
Good morning, Your Honor. Patricia Meaderneck for People, P84088.
Good morning, Your Honor. Shava Kirkland on behalf of Mr. Willingham, P84015.
And what are we doing?
Judge, Mr. Willingham would like to request a bench trial.
And Your Honor, people would like to request that this be set for a jury trial.
Really?
You want to do chair?
Yes, Judge.
And Judge, if this is going to be set for a jury, Mr. Willingham would like to avail himself of the offer.
Okay, what is it?
Now the court moves into the bond decision, and this is where the stakes become much more practical. The prosecution points to prior incidents involving the same complainant, while the defense emphasizes separation, a custody order, and the defendant's willingness to appear in court. A judge has to weigh these competing concerns when setting conditions of release. The goal is not simply punishment before trial, it's about making sure the defendant returns to court and that the alleged victim remains protected while the case moves forward.
I believe the offer is a plea under 7694A.
Straight up to the charge?
Yes, to the charge, 1 year of probation, anger management classes, and parenting classes.
Okay.
That is correct.
Understanding that those are recommendations based on what my probation department considered an interview, maybe those will be ordered as probation, maybe they won't.
Yes.
Okay. All right. Anything else from the people?
Your Honor, the other term would be no contact with the complaining witness except pursuant to a custody and parenting time order.
For the 12 months. During the 12-month period, that's what you're saying?
Yes, Judge.
All right. Mr. Willingham, have you discussed your rights and options with counsel?
Yes, sir.
You understand those rights and options?
Yes, sir.
All right. And you understand the possible penalty for the charge?
Yes, sir.
All right. Understanding all of this, are you pleading freely and voluntarily? Are you pleading guilty to domestic violence from January 4, 2024?
Volunteer.
Pardon?
Volunteer.
All right. Counsel, would you voir dire for me to get the facts I need?
Yes, Your Honor. My apologies. I should have had this pulled up already.
Incident date is January 4, 24, if that helps you.
Thank you. Mr. Willingham. Okay, Mr. Willingham, on January 4th, 2024, were you in the area of 10766 Oak Lane, apartment 11205 in Van Buren Township, Michigan?
Yes.
And on that date and time, did you come in contact with Imari Galloway?
Yes.
And on that date and time, did you touch Miss Imari Galloway without her permission?
No.
Okay. Judge, may I have a
Sure.
brief meeting? Thank you.
Arthur Wilson? Come on up, Mr. Wilson. Mr. Wilson, are you going to go forward today without benefit of a court-appointed attorney?
Yes.
All right. Looks like you talked to the prosecutor, and the prosecutor's offered to, yeah. Did you see what he's doing?
No, I didn't.
He's dismissing a drawable license suspended, but that we don't have. All right, so you're going to plead guilty to fail to display a valid license on February 15, 2024, correct?
Yes, sir.
And you understand your rights?
Yes.
Look your rights form over?
I didn't receive that,
Okay,
but I
well,
understand my rights.
okay,
I
and
understand.
you understand the possible penalty for the charge?
Well, he didn't explain that to me.
Up to $500 fines plus court costs and up to 90 days in jail.
All right.
You understand that?
Yes, I do.
All right, understanding all of that, are you pleading guilty freely and voluntarily to not having a valid license on February 15, 24?
Yes, sir.
Did you drive a vehicle at a location near Goddard and Middle Belt in the city of Romulus at that
Yes.
time?
Yes, sir.
And was your license valid at that time?
No, it wasn't.
All right. I'll accept your plea. What's the status of your license now, Mr. Wilson?
It has a hold out of Illinois, and I've submitted the out-of-state hearing to.
You gotta clear that mess up. Clear that mess up in
Clear that
Illinois.
mess up, and my license is good.
Okay,
It's just, it's a time thing now. They set up to 3 months. So-
okay. I wish you luck. Are you working, sir?
No, I'm retired.
From where?
Progressive Tool, Pico,
Okay.
Southfield,
How long were you with them?
29 years, and then after that, I've still worked another 8-10 years.
Okay,
Still working now and then.
good for you. All right. Fines a cost $300. That money's due within 5 days. What that means is we got to have it in our hand or we got to have a plan to get it. So if you go downstairs, you can pay it, make a partial payment, or just set up a payment plan.
Okay,
Understood?
yes, sir. Thank you.
You're welcome. Is Packer the one that Carrie was looking for?
No.
From Kalamazoo?
No, this one is last, he's stuck in the breakout room with Mohammed.
Thank you. All right, back on the record with Willingham. I can't say it. Willingham.
Okay.
So I think we established time and place. We just need to
Yes.
establish what happened.
Okay. Mr. Willingham, did you make physical contact with Imari Galloway and without her permission?
Yeah.
And is that someone that you have a child in common with?
Yeah.
You satisfied?
I'm satisfied, Your Honor.
People satisfied? So's the court. All right, sir, I'm going to send you downstairs to our probation counter. They're going to set you up to come back for a pre-sentence interview. Based on that interview, they'll put together a report and recommendation. You'll have a chance to go over that with counsel when you come back for sentencing. I'll look at that, and then the three of us will have a conversation before I determine what the terms of sentence should be. Understood?
Yes, sir.
In the meantime, bond will be continued. Counsel, if you go down, you can pick that sentencing date.
Thank you. Thank you, Your Honor. And Your Honor, I believe we requested this at the last hearing, but I don't think anything was ever done after. I'm just requesting a police escort, one-time police escort for him to gather something.
Yeah, you shouldn't have any problem doing that.
Okay.
Directly with the PD.
Okay, thank you. Thank you, Your Honor. Have a good
Yeah,
one.
civil standby.
Okay.
Good luck.
Thank you.
You're welcome. Parker's got a Van Buren local too. Did you see that? Parker has a misdemeanor from Van Buren. I see it, yeah. 321. Mm-hmm. Hey, when it's convenient, I'd like to go over your no-show list with you. Thanks. Can I have this?
Yep, that one I kept for you.
Thanks.
Is it alpha or is it
This one's by time, so whatever's easier for them. I've got one of each. I got the alpha and I've got the time one.
It looks like the actual memory that Terry's waiting for.
Mhm. That's the one that's in Kalamazoo.
Yeah, because we did have it scheduled for an exam and then Terry got a hold of everybody. No.
Okay.
Ms. Parker, your attorney is on. He's just in with the prosecutor, so we're just waiting.
Okay, thank you.
And then he'll speak to you when he's done.
All right, thank you, ma'am.
Joe? You know who this is?
what's your name, sir? Alexander Green.
Thanks, Jerry. Yep. Mr. Green, are you going forward today without benefit of a court-appointed attorney?
As of right now, I cannot afford an attorney as I've been.
That's why the court will appoint one.
I do not appreciate how I was just spoken to in
Okay.
the
So,
conference room. I will be providing.
so my question is, are you going forward today
Yes.
without an attorney?
Yes.
Okay. And Madam Prosecutor, your appearance?
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
What are we doing?
Your Honor, it's my understanding that at this time, defendant wishes to proceed pro se. I very briefly attempted to speak with him in the presence of a deputy. He was unclear as to whether or not he intends to remain pro se for the duration of the proceedings, or if he is just pro se for this hearing. If defendant intends to retain counsel down the line, I would request that this hearing be adjourned so that defendant.
Are you thinking you're gonna hire your own attorney?
Nope.
All right, so you're not gonna hire an attorney?
Nope.
Okay, so what do you want to do? You want to set this
Pro
for
se,
trial?
I'm fine with pro se. I just want to be,
How do you want to proceed? That's the question.
oh, with a jury trial.
Okay, and you're going to represent yourself in front of a
Yes, sir.
jury.
Yes, sir.
This is where the courtroom dynamic changes dramatically. The defendant has decided to represent himself and wants a jury trial, but the judge immediately has to make sure he understands what that decision actually means. Self-representation is legally possible, but it comes with serious risks. You still have to follow courtroom procedure, understand deadlines, handle evidence, and follow the rules of trial. And when frustration starts taking over, the judge repeatedly brings the conversation back to one question: what exactly is the legal issue that needs to be addressed today?
All right, I will appoint counsel to be here that day to sit second chair. You got any jury trial dates?
Oh, I'm sorry. Ma'am, it's never an active action. I can,
Okay, all right, stick around, sir. We'll get you a date.
Thank you.
So Jamie, just to confirm,
Orange is what arrived in the building.
present.
Yes, sir.
Thank you.
We have April 2nd. April 2nd. Okay. April 9th, 20. 29. Yep.
Back to Jamie. Thanks.
Jury. Okay. Judges, April 29th.
All right, Mr. Green, April 29th, 8:30 in the morning. Understood?
What is this for?
Your jury trial. You just said you want a jury trial.
Correct, but there will not be a conference, none of that.
No, that's what today's for.
So today we decided that I'm not.
Today you decided you didn't want to talk to anybody and you asked for a jury trial.
I tried to talk to him and he told me that I'm jumping ahead of myself. Everyone else that.
Okay, sir, listen to me. We're going to do this my way.
That's fine.
All right. You said you didn't want an attorney.
Right.
The prosecutor said you didn't want to talk to her. I said, how do you want it, sir? Do not interrupt me, sir.
I'm trying to.
Don't interrupt me.
Yeah.
I asked you how you wanted to proceed, and you said you wanted a jury trial. I got you a date. Now, do you want to do something other than a jury trial?
Yeah, ask a question.
Go ahead.
Every time I ask for a discovery packet, which is why I told him, I just tried to say the same thing. I'm just going to tell him that, and you can ask him to come back. Right?
You had a question for me. Ask it. I don't need history to hear your question. What's your question for me?
Why is it that when I express my rights, I'm talked to as if they don't exist in this county? Not only has Van Buren tried to kick my door in,
listen.
Never.
Van Buren doesn't work for me.
That's not the problem.
This is a court case.
I understand.
What do you have a question for me about the court case proceeding?
Who would I talk to that doesn't cut me off so that I can get the story out?
What story?
That I'm being literally pushed out of my home because I cry loud.
That's got nothing to do with what's going on here. You're charged with domestic violence. What's in front of me, sir, once again, you interrupt me. One more time, I will hold you in contempt of court. The first time, it's 1 day in jail. Are you clear about that?
I'm fine. I've done more
All right.
times.
You're charged with domestic violence. That's what's in front of me. So the only thing that I've got to determine or make sure gets determined is whether or not on March 1, 24 in Van Buren Township, you committed domestic violence. So if there's a jury trial, I'm going to oversee the jury trial and let the jury decide whether or not if that crime was committed on that date. Anything else that you've got going on where your rights are being violated and everything else, that's not in front of me today. If you've got some rights violations you want to proceed with, then you can file charges, you can file lawsuits, you can do whatever you want to do about that. All I've got is a domestic violence misdemeanor. That's the only thing that's going to go in front of a jury on April 29th. Does that answer your question?
Yes, I have one more.
Go ahead.
So what is the normal procedure if I get a defense attorney?
Normal procedure would be you show up for an arraignment pretrial, which was scheduled for today. You would talk to the prosecutor, or if you have an attorney involved, you would talk to your attorney. That attorney would get whatever information he or she thought was necessary at that point in time. They probably talk to the prosecutor to see if there was any offer on the table. They might discuss an exchange of information, which is called discovery. Okay? Then they, being the attorney, would have some more conversation with you and decide what the next step is.
Okay.
That's how it works. Yeah.
So I watched like 20.
And then comes one of the most memorable moments of the hearing. The defendant admits he watched around 24 YouTube videos to prepare for court. The judge's reaction highlights a serious lesson. Online courtroom content can be entertaining, but it is not a substitute for legal representation or actual legal advice. Every case has different facts and procedural requirements. Eventually, the defendant realizes that trying to navigate the process alone may not be working. His decision to ask for help could end up being one of the most important choices he makes during this entire proceeding.
26 YouTube videos before coming here.
Bad idea.
And this, I failed. So
Bad
I'll take
idea.
that L and
Don't watch video. Don't watch that crap on YouTube.
Well, I mean, nobody's answering. I've called so many times and nobody will. They just
Listen
tell
to me.
Wait, and then
Listen to me. The attorneys that we have on our pool of attorneys, when we say, here's one of your court-appointed attorneys, they're great attorneys. They've all gotten lots of experience. What they won't do is let you dictate how things happen.
Right.
Okay? But as long as you're willing to play the game as they want to play it, they'll do a great job representing you.
Okay.
You want to start over? You want to hit reset?
Yeah.
Okay. Do you want to go out and talk to Mr. Bitar again?
Yes, please.
All right. I'm sure he's more than willing to have you.
Thank you. I appreciate it.
All right. How they end up on Zoom?
I don't know, maybe they're out of town, I'm not sure, but they're on Zoom. Mohammed talked to them, I don't know how you know.
How could we do this?
Or do you want me to begin?
Everybody has it all the time.
I know.
I got his file up if you need the actual file.
No, I'm gonna, he's in my office now, he wants to talk to me, so.
Are you able to download it?
No, it won't download.
Not through evidence.com either.
No, I'm looking at the link you sent me earlier. 24.
Dan, I need a little assistance too.
Can you take this tomorrow?
No, it's his name. It's green.
GRE.
It's all there.
He doesn't have.
So when I click on the attachment.
I mean, civil infraction.
Okay.
Too.
And the evidence.com.
Well, because it's a reduction.
Okay.
Yeah, I have another evidence.com link with it.
And Mr. Dubin, just so you know, is running behind. He has, Conowalski and reading.
Okay.
And,
What's that?
but they said that he is on his
Yeah.
way.
I'll email it to her right now.
Heather, can you print out the discovery the discovery from Mr. Green, if she emails it to me? Because it's not downloading.
Yeah, is it in the file maybe?
I'm sorry.
Green. Nice and green tile.
Yeah.
I'm sorry, but you said you needed something else.
I've got an LLC that's on Zoom from Tennessee. They've made their deal with Muhammad. I just need you to stand there and say you'll represent him to enter a plea. Thanks.
Yeah, send it to me, Patricia, and then I'll.
Mr. McClure.
Yes, sir.
All right, Mr. McClure, you're on for HTC Transport LLC, correct?
Yes, sir.
All right, that's a good news, bad news situation. The bad news is because HTC is an LLC, I cannot let you represent the company in the court of law because you're not an attorney, I assume. Is that correct?
That is correct.
All right. The good news is I've got an attorney standing in my courtroom who is willing to enter an appearance for HTC. Would you like Mr. Bitar to assist you in this matter?
Yes, please.
Daniel Batar on behalf of HTC, Your Honor.
Thank you. All right. Mr. Bitar, I understand that the company is going to enter a plea of responsible to a civil infraction, fail to register motor vehicle, and the fail to register misdemeanor motor carrier violation would be dismissed. Is that correct?
Correct, Your Honor.
And Mr. McClure, that's what the company wants to do today, correct?
Yes, sir.
The misdemeanor is dismissed. Fines and costs on the civil infraction, $250. I need you to contact us through our website, Mr. McClure, and either pay that or set up a payment plan within the next 5 days. Can you do that?
Yes, sir.
All right. Any questions, sir?
Not at all.
All right. Have a nice day.
You too.
Patricia, let me know when you send that, because I have to go to my office to.
Okay.
put it.
I just sent it.
Okay, I'll go grab this.
He was on.
She just told me something about Reading. Did you catch that, Joe?
Reading?
Yeah, Heather just told me something about an attorney for Reading, I think. You didn't catch it? No, it's all right. She'll come back.
Oh my gosh.
Hopefully she can know.
I can open the PDF, so hopefully from the attachment.
Not a bad appearance rate today. Okay.
So the whole thing is it redacted, Patricia, already?
Yes.
In Reading,
Yeah.
you said Dubin's running late,
Yes.
but Reading's not here.
Oh. Okay, what about Connemallski? Is he here?
Is that a K?
Yes.
Let me find
There's
him.
another Dugan.
Let me find him on the list. Yeah, Konowalski, the guys have checked as here.
Okay, and Mr. Dugan on that as well.
I'm sorry?
Boykins is the last name.
Boykins with a
Yeah, we
B?
retained.
Judge, Jamie has the file.
Oh, okay. Counsel, your appearance for Mr. Boykins.
Deborah Sloso on behalf of the defendant, Mr. Deontay Boykins, who is to my left. Good morning, Your Honor.
Good morning. All right, so you're going to plead, Mr. Boykins, you're going to plead to fail to display a valid license on February 8th?
Yes, sir.
All right. Did you discuss your rights with counsel?
Yes.
Understood all those?
Yes.
Understand the options those rights present?
Yes.
And do you understand the possible penalty for the added charge?
Yes.
Understanding all of this, are you pleading guilty freely and voluntarily to the added charge today, sir?
Yes.
All right, did you drive a vehicle on February 8, 2024 near Beach Daily and E-Course?
Yes.
We got only one problem, that's not my jurisdiction.
Oh, it is E-Course, you're right.
No,
All right.
E-Course is mine, but Beach Daily
Oh,
isn't.
Beach
Beach
Daily.
Daily is a mile too far east.
So it's Taylor?
Yeah.
All right, motion to dismiss, Your Honor. For
Right.
lack of jurisdiction.
A simple traffic-related plea now turns on something much more technical. Jurisdiction: the defendant was prepared to plead guilty, but the court notices that the alleged location may fall outside its legal authority. That matters because courts are limited by jurisdiction. A judge cannot simply decide every offense that happens anywhere. The defense immediately recognizes the issue and requests dismissal. It's a perfect reminder that courtroom outcomes can sometimes turn on details that seem small to everyone watching, but legally those details can determine whether a case can even proceed.
Granted.
All right, thank you. Can we wait for an order?
Sure.
All right.
You can present an order and I'll sign it.
All right, what will be in the register of actions?
Yeah, it'll be in the
All right.
register of actions.
Okay, cool. Is it dismissed with prejudice?
Can't do that with prejudice because we haven't had a witness for you.
All right, okay, thank you. We'll take it.
Mohammed, talk to me when you can. No, I would expect him to. It says Ron was.
And, for Parker and Slack.
You ready? Are we ready on Parker Council?
We are. Waiver.
Thank you. Your appearance, sir.
Yes, good morning, Brian Schaff on behalf of Ms. Parker, P68271.
All right, Ms. Parker, can you hear me okay?
Yes, I can. Good morning, Your Honor.
Good morning. You've discussed your rights with Mr. Schaff. You understand your rights and the options they give you?
Yes, I have.
Do you understand the purpose for a preliminary exam?
Yes.
You understand that if you waive the exam today, that means your next court date will be at the circuit court level, not at the district court where I'm at right now.
Yes, I do.
Understanding all of that, is it your desire to plead or waive the exam today?
Yes, it is, Your Honor.
All right, I'm going to enter a waiver. Arraignment on information date for you is going to be on the 27th at 9 a.m., March 27th.
Okay.
Thank you, Your Honor.
So anything as to bond?
No, Your Honor.
All right. And counsel, Ms. Parker's got a misdemeanor charge of retail fraud from Van Buren. I'm going to hook her up with a pretrial date for March 21. She can talk to our court-appointed attorneys then when she's here.
Can I say something?
Yeah, go ahead, Ms. Parker.
I was sentenced in Wayne County back a while ago, and that was one of the charges that I pleaded guilty to my case in Wayne County, and they were supposed to dismiss that retail fraud and another misdemeanor case out of Wayne, the city of Wayne. So that one was supposed to be dismissed. Okay. I'm not sure.
Somebody forgot to tell us about it.
Okay, what do I do?
Yeah. Who's your attorney on that case?
Oh, I don't remember. Sorry.
Well, you know what? Let's do it this way. How long have you been in custody right now?
I've been here since February 7th, but I've been in jail since February 2nd of 23.
Yeah. So if you want to plead guilty to this retail fraud, I'll give you time served and close the file.
Okay, that'd be great. Thank you so much.
All right. So let's get the facts. On November 21, did you try to take some merchandise from a store in Van Buren without paying for the merchandise?
Yes, Your Honor.
Walmart or Meijer?
Walmart.
I'll accept your guilty plea. 30 days in jail, time served, close file. Good luck with where you're at.
Thank you so much.
Thank you, Your Honor.
You're welcome so much. You as well, counsel. Yeah. Better for everybody that way.
Looking back at this entire hearing, one theme keeps appearing. Courtroom procedure matters, from bond conditions and plea agreements to jurisdiction self-representation and preliminary examinations. Seemingly small decisions can completely change the direction of a case, and the earlier defendant's experience is probably the clearest lesson of all. Watching courtroom videos may help you understand the atmosphere, but it doesn't replace knowing the law or having qualified legal counsel. After nearly 44 minutes of hearings, we're left with one simple takeaway. In court, understanding the process can be just as important as understanding the accusation itself.
It was touch and go. It was touch and go for a minute. I give him credit for admitting that he watched 20 YouTube videos that gave him bad information. We should like snippet that out and save it, right? It's like, look, is this what happened to you?
Yeah.
Still got an awful lot of files.
Don't forget, we have 12 just starting at 11 o'clock.
Oh, yeah. Not much chance of hitting that at the webinar today.
Oh, I'm sorry, 12 starting at 10:45.
I got news for you. Next time somebody says something about how small Jeff is, just saying, it hasn't exactly moved fast today without it.
That's true, that's true.